Hi, my name is Goldman, and I'm an attorney with Goldman and Associates, and I want to tell you a little bit about initiating a divorce. How do we start divorce proceedings, and what happens in the beginning? Well, you're going to get a lawyer, and you're going to hire somebody to help you out, but this is what's going to go on in the way of initiating the divorce. Once you provide all your intake information and the attorneys that are representing you have all of the relevant data together, they are going to draft what's called a complaint for divorce. This is a lawsuit. This is you're suing your spouse for divorce. You file the lawsuit. It has very specific requirements that the court rule mandates. And then it's going to be filed in the circuit court in the county where you reside. Now, what will happen is, once it's filed, it will be randomly assigned to a family court judge who sits in that county, and that judge will order or issue a summons that goes along with the complaint. A summons is really an order to take action. The summons is what tells the parties by such and such date certain things have to be done in the way of answering the complaint for divorce. So once this occurs, the court will then issue the summons, and then they will send both the lawsuit papers, the complaint, and the summons back to the firm. When we get them, we will then turn them over for service. And by service, I mean you got to get the papers to your spouse somehow. It could be by a bailiff, by a process server, it could be certified mail. They can come to the firm and pick them up and sign an acknowledgement of service. But somehow, we got to get those papers to that person, and from the time that they get those papers, they have a limited amount of time to answer. Assuming they've been served locally, they generally have 21 days within which to do something. And those 21 days, that'll typically be the time when they go out and hire their own lawyer. And then that lawyer will interface with the firm, and we will establish what we're fighting about and what we're not fighting about. What we're not fighting about, we can put that over to the side and devote our energies and resources to those things which the parties are fighting about, which obviously are the things that they really care about. Once this is undertaken, the other lawyer for the other side files an answer. The court has everybody in, all the attorneys, all their answers, and then the court begins to set up a schedule of events. These are events that the court, meetings that the court convenes, either in person or virtual by Zoom or whatever, and the court sets these up to help move the case along. Ultimately, the court's going to want to find out, where do we stand, what are the impediments to resolution, and is there something the court can do to get the case to get into a settlement posture. Many times this is when the court imposes the obligation for the parties to go to a mediator. And the mediator will be sort of an intermediary that the court utilizes to try and bridge the gap between the plaintiff's side and the defendant's side, between the father and the mother. They get that together, and in a lot of cases this is a very successful process in settling cases. You should be aware that, generally speaking, over 95% of cases that are filed in this manner never go to trial. Only a few, maybe between 5 to maybe even 3 to 5 out of 100 go that way. The rest of them are resolved, either by agreement of the parties, by mediation, some alternative dispute resolution. But most of these cases resolve through this means, so it's a very, very effective way for the court to manage these cases. Obviously, this is very technical, and there are some issues that are going to be case specific for you. If you have any questions, reach out to us, and of course, we'll be glad to help you out.